At this time, I'd like to have Jerry Dahl come up and make a few comments.
Well, I really appreciate being able to be here, and thank you for having me up. I appreciate the staff and the commissioners and planning commission letting me work on these regulations with Richard. You've got great staff, and it's been a fun project. I don't have PowerPoint. I'm kind of old-fashioned, so I just have some notes. But there's really two questions that you hear a lot, or you likely will hear. I've heard before, and we'll hear tonight, which is, does the county have the power to do this? And secondly, should it do this? My job is to mostly answer question number one, because it's more of a political choice how much you do, whether you do something and how much you do it. But it's certainly a legal question whether you have power to do that. And the reason I mention that is it's sort of the elephant in the middle of the room. As you know, there have been letters flooding in from state agencies, from the industry, from the Attorney General's office, saying, look, you don't have the power to do this, or at least your powers to do this are a lot more constrained. To be fair to those letters, a lot more constrained than you're acting here in terms of the scope of the regulations you're addressing. And it's my job to describe, why I believe the county does have this authority. There's no question that this is an evolving area of the law, and I think we know that because we are getting the letters and calls and whatnot from not only industry but state agencies saying, gee, why don't you have us do that? So I'm certain that process will continue, as is true in so many aspects of Colorado law. Different interest groups push, and they try to take over more of an area, and then they get pushed back. And it's a constant little struggle, and I'm involved in that struggle, but I'm on the county side on this one. And let me just give you, I won't say the legal short course because I don't want to bore you to tears, but on the issue of does the county have the power, because that question is going to be put out there, has been put out there, and there have been any number of statements saying you don't have the powers that you're attempting to exercise. And as usual, it's not that simple, and I can tell you a few things. First, let's not forget the counties and municipalities in Colorado have land use authority. Counties and municipalities are the main entities that govern land use. They're where you start. You don't start with the state when you're regulating land development. If Pulte Homes comes to the county and wants to put up a subdivision, you go to the state first. The county is what regulates land use, and that's a very broad power, and it's found throughout the statutes. The power to regulate land use is given to cities and counties. So you start there. And that authority applies as well to oil and gas operations. They're not some sort of special activity that isn't a land use activity. Of course it's a land use activity. You grade things, you grade property, you put up improvements, you build haul roads, you have land use impacts. How's that any different when you think about it from a regulatory standpoint than a commercial operation, than a 50 lot subdivision? These are all activities which we're going to permit, but permit with regulation, and who gets to do the regulating is the question. What I'm saying is that oil and gas operations are also land use operations. And because counties and municipalities have the power to regulate land use, oil and gas operations are to be regulated also by counties and municipalities. Now, as with lots of other arenas, the state legislature has gotten involved and has given other authority to regulate oil and gas operations to, among others, and principally the Colorado Oil and Gas Conservation Commission. And of course that means that they've got a role too. But what we forget, or what I think sometimes we're encouraged to forget, is that, gee, if the state has a role, we must not have one. And very frankly, that skips a step. It forgets what I started with, which is, let's remember, counties and municipalities are in the land use control business, and it's very common for state agencies to also have a role. The Colorado Water Quality Control Commission on water quality in rivers. Does that mean that if the Colorado Water Quality Control Commission has regulations on water quality in streams, that the county all of a sudden, just because the state has a role, does that mean the county has no role? And of course the answer is no. And of course the answer is that every county municipality in their land use regulations addresses water quality. And they can do that despite the fact that there are also state regulations on water quality. The real tension is when the argument is made that, well, the state regulations preempt your local regulations on this subject. And we're all going to hear that word more than enough to make, we're all going to be very tired of hearing that word when we're done, because you'll hear it from literally everyone. You're preempted, or there's an argument of preemption, that because the state has done something in this arena, that means that the counties can. And of course, it's a little more subtle than that. But the state legislature is in charge of that. The state legislature can say, since counties are creatures of statute, they can say, counties don't have the authority in this particular area, and they can say so affirmatively. But the legislature has not done that in the oil and gas arena. It has not done that. Sometimes we're led to believe that that's the effect of what the state statutes provide, but it's not the case. There's really three different ways that you can argue preemption. One is what I've just said. The legislature says, you may not do this at all. And there are examples in the statute where that's true, but it's not true yet in oil and gas. It's not the law yet. Secondly, the argument is, well, and this one has the most traction, I think, the local regulations operationally conflict with the state program and frustrate the state's purpose and and destroy or materially injure what the state's trying to do. And that's an operational conflict. And that can be a form of preemption, but it means on a case-by-case basis that you have to have some hearing to determine if these regulations actually have that effect. If these county regulations on this subject, on erosion control, actually do frustrate the state's program. And lots of people have opinions about that, but you don't know the answer to that until you've had, as the courts say, and all the cases say, an evidentiary hearing. And it's tempting, and you'll probably hear testimony here today, it's tempting to say, well, let's skip that step. And just because the state's got a program, let's just assume that that's going to be operationally preempted, and so don't bother. And that's, as I say, skipping a step, and I don't think that the county is required to do that. Lastly, there's something I already mentioned, where the state has occupied the field, where its regulations completely cover the waterfront. There's no room in that particular arena left for local regulation. You're going to hear that argument too. But it's not true that just because there is a state regulation on a topic that the state has occupied the field. What's the example? Water quality protection we just mentioned. Water rights, the exercise of water rights. There are water rights laws in the state of Colorado, and priority system, believe it or not, used to practice water law. But you'll notice that the courts have consistently upheld the rights of local governments, including counties, to regulate the land use impacts of water projects. Do it all the time. All those counties in the West Slope that put together regulations being hard on the Denver Water Board and Roaring Colorado Springs for Trans Mountain water diversions. I realize I'm on the East Slope now. I have to be more careful about that. But they put together those regulations, and the city said, you can't do that. That's our right to exercise water, and there are state statutes on the regulation of water, and counties, you don't have the power to be in this arena. And the courts did not agree. And said, of course you do. It's a land use matter. Let me kind of wrap up. If it were true that counties don't have these powers, then we wouldn't see things like a bill, Senate Bill 88, which was just dropped into the hopper in the legislature a few days ago, that explicitly preempts county regulation of oil and gas whatsoever. And I expect that that's going to be an industry-supported bill, and I would hope that it does not pass, and don't think it will. But it illustrates the fact that if that bill has to be introduced, there must be powers that counties and municipalities have that you need to preempt. So in a sense, it sort of proves what I'm saying to you. And it's nothing more than both the counties and the state have a legitimate role in the regulation of oil and gas operations. What comes down to, for me, the bottom line is that, you know, the county's got a substantial role if it wants to exercise it. I think the function of the planning commission here tonight is going to be to hear from you on, you know, what issues are of most importance to the residents of the county. And the planning commission, later the board of county commissioners, will need to take that and fold that into any changes or adjustments that they would make to these regulations. I live in the real world, and I understand and appreciate that there will also be pressure from industry and pressure from the Oil and Gas Conservation Commission, who's represented here, I think, tonight, to say, well, you really should just rely on the state to do this work. And the state has an important role, and I agree. The Oil and Gas Conservation Commission's entered into a memorandum of understanding with Gunnison County, and you're probably told, well, you know, that's a good example of Gunnison County sort of, you know, we're handling it for them. But that's a 4-page MOU, and it really just allows the county to take over some inspection roles. Does not eliminate Gunnison County's regulatory role in oil and gas. So, you know, you'll probably hear, look, you know, you can trust us to do this job. And I think that there's no question a huge role for the Oil and Gas Conservation Commission, but does that mean there's no role for Elder County? And I have to tell you, no, I don't agree with that. If politically you decide that there's no role, that's a different matter. But it's not okay to say that you don't have the power to be at the table. Appreciate your time. I'll look forward to hearing all the comments later tonight. Thanks.
Thank you very much.